what you want to do is basically make them stand down if at all possible or if anything, make them come in with reduced charges and filter those charges in before you even walk into court.
How can a lawyer help if you're accused of domestic violence? We're going to talk to attorney Mark Deniz about that on today's Ask the Lawyer. Mark, thank you for joining us.
Great to be here.
Great to have you. So, what is your experience representing people accused of domestic violence in San Diego, and how do you see these situations typically play out that lead to an arrest?
Yeah, I've been practicing now, getting close to 20 years, and I spent almost 10 years of that as a prosecutor, including time on the domestic violence, the family protection unit here in San Diego. Domestic violence is one of the more serious charges that individual can face. What you want to do is it really stems from a dynamic in a relationship that happens often. People fight, and sometimes, I will say often, they get overdone, they get overblown. And I think because of the system is so knee-jerk to make an arrest, a lot of people who did not commit domestic violence or just actually was in a very bad fight can end up being swept up in a domestic violence arrest.
So what can be done immediately after an arrest for a person who's in this situation?
Yeah, so the arrest, if you can imagine someone has a file and they have their name on that and the file makes its way through a few different junctions, if you will. I always look at it as a train track. It goes from a patrol officer to a detective, inevitably to a district attorney, and to the courthouse. What you can do is you find good quality representation to contact immediately the police agencies, to the prosecution, in hopes and with a working goal that your file never makes its way to that final destination of the courthouse. You let them know your side of the story. Let them know who they're going to be looking at potentially to file charges with. The prosecutor, at the time, if they're just reading police reports, all they see is a booking photo of the individual and a police report. What you want to do is say, this person, here's their character. This is their lack of aggression, or this is their lack of violence that they've had in their past. This is who they are. And coupled with that individual's character, with the attorney knowing that the prosecution, if they know that this attorney knows this field of law, what you want to do is basically make them stand down if at all possible or if anything, make them come in with reduced charges and filter those charges in before you even walk into court. So I know it, like with us, we like to walk in, or at least when we pick up a case, we always start off with not wanting the case issued and getting it dead and on arrival.
And you touched on this a bit, Mark, but what are some of the common issues or factors that an attorney can put in a mitigation packet, and tell us why?
Yeah, so the mitigation packets, or we call character packets, but these are basically presentations and introductions of the characters that are in the police report. It'll have a little bit about who that individual is. It will explain who the complaining witness is. Is it an ex-girlfriend who's jealous? Was it just a fight that got bad? Was it a loving couple that just went out that night, maybe had a little bit to drink, both of them, and the neighbors call? What you want to do is have all that information. You explain a little bit about your side of the story to them, and it helps provide context. So when they're reading that police report, they're not coming to their own conclusions, but they are seeing the backstory that usually starts off, because the police report just says, I arrived at a location, rather than saying, this is how the whole night went through, or this has been going on the last few weeks. And you want to provide that. And that's a really good working approach to getting that best possible outcome on a case.
And I know you have a lot of experience handling cases like this, but what if the accuser doesn't want to press charges? Can the prosecution still move forward then?
Yeah, that's a good question. In the old days, they used to be the prosecution and the police would say, "Would you want to file charges?" And when that person declined to file charges, they would walk away, and inevitably no charges were filed, and the person was good to go on its way. Over the years, they saw that with abuse victims, that they ended up going into a situation where they saw that people that were forming of abuse would, for one reason or another, maybe someone would lose their job, they would decline to file charges. Well, in California, basically, the prosecution has taken that choice away, basically because they believe that that person could be abused. So it's a factor whether they decide to file charges, whether that person wants to, whether the prosecutor takes into consideration. Sometimes they do, sometimes they don't. But the reality is, if somebody does not want to file charges, that does not stop the prosecution from filing charges.
What's the difference between a misdemeanor domestic violence charge and a felony domestic violence charge in California, and what are the potential punishments there?
Yeah, they're both very serious charges. I mean, anytime you have domestic violence, even at the lower misdemeanor levels, it can have a lot of ramifications. So a felony, obviously, is one that someone could do prison. Usually, if it's in the domestic violence felony range, it's going to be potentially a strike offense. We're talking that the ramifications and the consequences on those are far-reaching. You could be talking about felonies, prison time. There's going to be classes involved with the felonies. With misdemeanors now, you're still going to have your classes, but the likelihood of jail time is less.
So how long does a domestic violence charge stay on a person's record? Is it there forever, or does it eventually go away?
It stays on forever, and not only is it it's a very rough charge to have on the record. It's has its own stigma to it, but then it has far-reaching effects. For one, it's much more difficult to expunge, to reduce. I know it has weapons, lifetime weapons charges that you have a lifetime weapons ban. So even the most de minimis misdemeanor charge could have lifelong effects.
So what if the case then proceeds to a criminal trial and it's not dismissed or no plea agreement can be reached? What happens then?
Yeah. So if you present a character packet and then you review the evidence, you examine the evidence, and you litigate with the prosecution the facts of the case, you tell them your side of the story, and at the end of it, they still decide that they're going to proceed with a prosecution. They believe that they can prove those cases or prove the charges. You want to call them out on it. The reality is, in most cases, it benefits the individual to challenge the prosecution and go to jury trial. So what would happen is, if you work with your client and you see that it cannot be proven beyond a reasonable doubt, you want to get that matter set for trial. And in California, most charges result, I believe it's a 93% conviction rate for most charges that go to jury trial. Domestic violence is different, and the charges are, the odds are much better, especially if you have a good proven approach and a good defense.
Well, Mark, a lot of fantastic information. We really appreciate you joining us today. Thank you so much.
Oh, thank you. It's been a pleasure.
Great to talk to you. And that's going to do it for this episode of Ask the Lawyer. My guest has been Mark Deniz. If you want to ask Mark a question about your situation, call the number on the screen. Thanks for watching. I'm Tom Mustin for Ask the Lawyers.